Welcome to this week's edition of It's Chaile Time. If you are in the HR or the legal fraternity, you're in that kind of profession, your life and my life has changed. You know, when you look at the law is a book of black words on a piece of paper. And this is sometimes, especially in labor law, why labor law is such a niche and so challenging. You know, if you think you know labor law, think again, because the interpretation and the application of these laws are getting developed and evolved through our courts on a daily basis. And on the 25th of October, our lives have changed yet once again. But before I start, I just really, from my side, also want to congratulate South Africa and the Springboks for winning the Rugby 2023 World Cup in France. Yeah, it was amazing, and it's a great team. And to being South African, that is reminiscent of who we are. We are winners. Awesome. So, but I just want to take a sip of coffee because this is landmark. You know, every now and then you get this massive case that just changes the way we do things, the way we think about things. That is huge and it's quite important. And moving forward from this very day, the way we do litigation, I suppose, from an element of maternity leave. That's right. I suppose we all are already shocked. We've all seen in the media and our networks that there's this high court case that came out that was ruled on the 25th of October 2023. It's like last week, I think it's like Thursday or something. And it's changing the way of the workplace. I don't know if it's going to be indefinitely because I suppose the Minister of Labour will appeal. Maybe they will appeal or not. But as things stands right now, it is quite revolutionary. Oh yeah, that's a nice word. It's quite revolutionary. And I need to take my coffee. Just so I can calm down now, because I have to go back to all my clients now and say, how's it? Our lives have just changed. Okay, so the case law I'm talking about is Werner van Wyk versus the Minister of Labour in the High Court. Basically challenging the constitutionality of the maternity leave provision in the Basic Conditions of Employment Act and the Unemployment Insurance Fund Act. Now, we're basically talking about Section 25. Now, just from my side quickly, I have for many years identified, this is the Basic Conditions of Employment Act, by the way, I've identified some problem here. You know, if you read, the main section here, or the main provision here, is Section 25 in the Basic Conditions of Employment Act that deals with maternity leave, okay? It states, subsection 1, an employee is entitled. Now, who is an employee, okay? An employee is entitled to at least 4 consecutive months maternity leave. I've always wondered, but this section in itself does not exclude a father. I know it's been custom that it's always a woman that gives birth by natural means, I suppose, or that gives birth, okay? So it always applies there. But there's nothing that I can see in the definitions of the Act that it is worded in that way that this refers to a female that actually gives birth. Even though, even in this court case, that is the common understanding of it. But I'm just highlighting an issue I personally always had with this provision. And it also does not necessarily say that a surrogate mother cannot have maternity leave. It doesn't say a father can't have maternity leave. It doesn't say that somebody adopting a child cannot have maternity leave, even though that's never the way it's been applied, okay? So, this is what happened to the Van Wyks, and this is what gave, or that initiated this challenge at the High Court in terms of the constitutionality. We're basically dealing with Section 9 and Section 10 of the Constitution that protects a person's in South Africa's right to equality and human dignity. So in essence, this case is saying somewhere we are unfairly discriminating, which is infringing on the human dignity of somebody, okay? So in Mrs. and Mr. Van Wyk's story, in a nutshell, Mrs. Van Wyk she's a small business owner. She got pregnant, gave birth, but She could not take off for 4 months because, if you're a business owner, you don't really subject yourself to the basic conditions because you're not technically an employee, you see. So business owners don't get leave, okay? They don't get maternity leave. You need to figure out life for yourself. So, and if you're a big business, fine, you can probably take off because there are people that can replace you and help you out, whatever. But if you're a small business owner, how do you take off? In her case now, a business was threatened to close down if she was not available for 4 months. So naturally, she wanted her husband to have 4 months maternity leave to bond with the child, both of them, but also to nurture the child, okay? Problem, he can't have maternity leave, okay? So, yeah, he can have his 10 days parental leave, I suppose, but it's just not enough, you understand? So there's a bit of a legal question there, and which put people a bit of in a predicament. So, okay, but so that is, I suppose the issue in law. Now, in 2020, the legislator brought in extra provisions in Section 25B, A, B, and C that deals with parental leave, also called paternity leave for some strange reason. Because once again, we say in a lame way paternity leave, but it actually says parental leave. And once again, it says an employee. So this is a bit of a misconception to think that a father is the one who's got access to parental leave, the 10 days now I'm talking about, because it doesn't say so, it says an employee. You see, so these provisions are a bit messy, you see. And then you get adoption leave where a parent, an employee, can take 10 weeks, and commissioning parental leave where you can have a choice, either take parental leave of 10 days or take 10 weeks. But why do we have these leave provisions to start off with, okay? It is to recognize that a child needs nurturing and needs time to bond. But primarily, the way Section 25 of the Basic Conditions is written, it sort of presumes a few things. Like, first of all, only females nurture children. Maybe historically it was true, but we live in a day and age where that's not necessarily true anymore. If you think in modern day life, it's not only a man that has a job, you see. Women also compete in the marketplace, and sometimes, women are also tied up. Often women are also tied up in duties in the company she works for, and then it is the husband that must take the child or children to school, pick them up, to take to the doctor. You see, so in the day and age we live in, anyway, I don't know how many husbands there are out there that on their own can provide for a family. I mean, ons is net 'n arm daarvoor, né? But anyway, yeah, so we live in an era where it's both parents' responsibility to bond with a child and to nurture a child, which is quite important. So that is the one element of discrimination, between husbands and wives, or let's just say females and males, men and women, who's got a child, But then there's the other element of discrimination too. That is between the different kinds of parents, if I can put it this way. Why must there be a differentiation between a woman giving birth or a woman who adopts a child? Or even if there's a surrogate agreement in place, why do we differentiate between them? So what is, just a bit of a sideline, what is discrimination? Okay, it's a bit of an objective test. So we're asking ourselves, does this provision separate or differentiate between classes of people? Okay, and if it is found that it does, either on an arbitrary ground or in a direct listed ground in terms of Section 6 of the Employment Equity Act, which typically deals with gender, religion, sex, HIV status, age, those kind of things. Once you've established that there are discrimination, then the next question is, does this discrimination constitute to unfair discrimination, because not all forms of discrimination is necessarily unfair. And that is what this case was trying to resolve, the equality. So basically I'm jumping to the end here now. So basically the result, the conclusion of this case, before we discuss it in a bit more detail, is that the judge actually found that the Basic Conditions of Employment Act in terms of Section 25 was unconstitutional. It's offending Section 9 and 10 of the Constitution, as well as the UIF Act. There are sections there too, and it's now being replaced. These sections are now being replaced basically, we're going to read with what has been replaced now in a moment, but basically it's been declared the following, that number one, these sections unfairly discriminate between mothers and fathers. It unfairly discriminates between one set of parents and another. Basically, the different sets of parentship is those where a child is been naturally born from a mother, or conceived via surrogacy, or adopted. So let's just see quickly what this sections had been replaced with. Okay, let's just get my law out here. I'm not going to go through everything because it's quite a substantial list. In a nutshell, there's been replacements on the following sections, certain sections that was deleted and being replaced, okay? We're talking about Section 25 of the Basic Conditions, 25A of the Basic Conditions, 25B of the Basic Conditions, and 25C of the Basic Conditions. In terms of the UIF Act, we're talking about Section 24, 26A, 27, and 29A deleted and replaced, okay? So in terms of the Basic Conditions, let's just go see quickly what are the deleted provisions and what they have been replaced by. Now, let's just read quickly Section 25, subsection 1. This is the main provision that we are actually dealing with. Even though there are certain provisions that was deleted in 25A, B, and C and being replaced, but the main frame, if I can put it this way, is Section 25, subsection 1 that says, an employee is entitled to at least 4 consecutive months of maternity leave. Okay, right, let's see here. In Section 25, subsection 1, the one I just read to you, the provisions are deleted and substituted with. So that means that whole subsection 1 no longer exists. The one that says an employee is entitled to 4 consecutive months maternity leave doesn't exist anymore, okay? It's been replaced with the following. One or other parent shall take the whole of the period. So either the man or the woman can take the whole period, okay? Or each parent shall take turns in taking the leave. So you can decide between the two who's taking what, okay? Or both employers, that's now the companies, okay, must be notified prior to the date of birth in writing of the election, and if a share agreement is chosen, the period or periods to be taken by each of the parents must be stipulated. I suppose this is where the administrative complexities are coming in now, because now you have not only 2 parents in this mix, but you also have 2 employers, okay? And these 2 lovebirds, they must decide now who's taking what. Is one taking 1 week and the other one 3 months and 3 weeks? Or is the one taking the first 2 weeks and the other one the following 2 weeks, and then this one again 2 weeks and the other one the following 2 weeks, until the whole 4 months has been exhausted? And the complication is now there must be some kind of communication to both employers. Now, it does not say that the one company must now talk to the other company. I suppose practically how this is going to look like, we all will probably have to amend our leave application forms to basically provide for information to be shared by the person who's in your employ in terms of who will be taking what leave between the 2 parties now, okay? And I suppose the other party will be doing the same thing. Now, obviously, there are loopholes here. There are a lot of questions to be asked, in terms of what if the people lie, or if they are dishonest, just so they can both milk 4 months. The one can easily tell you, I'm taking the full 4 months, and my other partner will be continuing working. But that partner by also be telling that employer, no, they'll be taking the 4 months. So both take 4 months. So there are obviously complexities. But look, at the end of the day, I don't know if somebody's willing to put their jobs on the line for lying, because if it comes out, you'll be dismissed, I suppose. So don't do that, okay? But that's what we are waking up this Monday morning to. What is it now? It's the 30th of October. This is our new reality as far as maternity leave are concerned. So that's the big one that's changed. Okay, then in sections 25, subsection 2, just the next one, which says an employee may commence maternity leave. It just says parental. They are replacing the word maternity with parental. Okay, so it basically comes down to a parent. A parent can take maternity leave. Let's see some of the others. And this is now also nie snaaks nie. Anyway, section 25B and C, okay? I think I'm missing one here, hold on. Yeah, section 25A, B, and C, okay? Now, section 25A, let's just see what that deals with. It deals with parental leave. Now, remember with parental leave, you can take 10 days, no? It says, once again, an employee who is a parent of a child. Let's just see what it now says, because it's been deleted, okay? It's now being replaced with an employee who is a parent of a child is entitled to the leave stipulated in section 25(1). So where it used to say an employee who is a parent of a child is entitled to at least 10 consecutive days parental leave, it now says you're entitled to maternity leave. But once again, there's complications. And if you read 25A and B and C, they don't delete the entire section. It's only section 1, subsection 1. So it basically means parental leave, you are entitled to maternity leave. But what about the rest of the provision? That still speaks about the elements of parental leave. Don't know, okay? This next section, 25B, adoption leave. Once again, subsection 1, as it say now, an employee who is an adoptive parent of a child who is below the age of 2 is subject to subsection 6, entitled to adoption leave of at least 10 weeks. Replaced. Maternity leave. And the same with commissioning parental leave. Let's read what it says. An employee who is a commissioning parent in a surrogate motherhood agreement is subject to subsection 6, entitled to commissioning parental leave of at least 10 weeks consecutively, or the parental leave referred in section 25A. Replaced. Maternity leave. So what the court is basically saying is, why do we differentiate between people, men and women, or different forms of parenthood? If the reality of the matter is the leave is provided in the first place to nurture the child, are we saying that an adopted child doesn't need nurturing? You see, it doesn't make sense. It's not logical. An adopted child, I suppose, needs nurturing and bonding with both parents just as much as a child from a surrogate agreement, but also a child that was naturally born. It's really the same thing. Now, I'm not a scientist, so for those of you who are psychologists, whatever, don't shoot me. I'm merely summarizing what the court is saying here. Okay, so yes, I suppose the Minister of Labour may and will appeal, because their approach to this case was, and their main issue here is that the courts don't really have jurisdiction to deal with this matter. And the reason being is because laws are not made by the courts, but by Parliament. So it's not up to them to change laws. But the court hit back and said, yeah, but the fair application of it is. So, the fairness of those laws is within their jurisdiction. So you can't make laws that offends the Constitution and think you can get away with it. And also, second to that argument is the fact that, it obviously has a budgetary impact now on the South African government, the Department of Labour, I suppose, because, more people will need to be paid now because, where, let's just say a father used to get 10 days parental leave, now he can get 4 months, so I suppose there's budgetary constraints. But how our courts are, no? Inconveniences is not their problem. Find the money, I suppose. So, yeah, basically, so this is our new reality. NIASA also joined the argument and basically fought for employers to, try to protect them in terms of the operational, logistical, and for some companies, I suppose, the financial impact of these decisions. Because as you know, some employers, they actually do pay for maternity leave. It's like a benefit. Ja, hulle gaan nou baie betaal. There's going to be a lot of payment coming out now, So, look, these are the complexities, we'll wait and see. I am sure there will be appeals. But how that may look like, that the court is giving the legislator or parliament 2 years to amend the laws. But still, regardless of the fact that we are waking up to a new morning, I do think these matters need to be addressed. Because on the face of it, the prima facie case can be made that there is discrimination here. We don't live in the era anymore where it's only the woman's responsibility to nurture a child and a child is only bonding with a female. I think those days are sort of gone, and our laws needs to change with the times that we live in. I mean, there are other elements too. This is not the only element of a society that need to eliminate unfair discrimination against women, for instance. One element, for instance, for me is the matter of payment. Why must a woman, or let's just say now a parent who's got a child, you can claim UIF, but as we all know, the UIF payment is a fraction of your salary. Why must a woman be suffering with less income at a time when she needs it the most, just because she gave birth to a child? It's almost like a curse. You're getting punished for giving birth to a child, which builds society, by the way. The lawmakers are all born from a child, by the way. But hey, when you gave birth to a child, you're not going to get income. Or you do, but you're going to get a very small income. And then we still say it's a benefit. Thank you from the government. Isn't that unfair discrimination? The day you are born as a woman, you're like, oh, yeta, the day I'm going to give birth myself, I need to start saving, eh? But the man doesn't have to save. So there are many elements or questions in law from a societal perspective. We can talk about other elements too, like, why must the woman always, or predominantly, when the child is sick at the school, why are they always phoning the mum? No, man, gaan bel die pa. The father will say, no, I'm busy, but the woman can't say I'm busy, no? So I suppose the courts, that is their responsibility, to eliminate unfair discrimination in the workplace, and sometimes we create laws that unintentionally offends, okay? But yeah, so that is basically for this week. We obviously need to watch the space. I think many of us will have tongue-in-cheek responses to our employers and our bosses and our clients, because it's like, this is like neither here nor there. This is what the court is saying. We don't know if there's going to be appeal. There probably will be. Your employers are not going to be happy. So enjoy the victory of the box. Don't think about these things. First focus on the box. Have some coffee. Oh yeah, my coffee. And then slowly but surely think of how you're going to approach your clients and approach your bosses, your employers, because they're not going to be happy when they hear what you have to tell them. Until next week, like and subscribe, and enjoy the rest of your week. Bye-bye.